Be seated. You have a motion now, Mr. Hayes.
Yes, sir. Your Honor, at this time, I respectfully move for leave to withdraw my appointment, as I understand, having now expired.
All right. Let the record reflect that motion of Mr. Hayes, appointed by the court on the motion of the defendant, that he receive counsel for that limited purpose of the competency proceeding, and he having discharged his duties and the court having ruled, I will discharge him of record as counsel. And Mr. Hayes, I think it has been agreed between counsel that if you will stipulate or send forth your motion of time, the court will enter an order concerning your fee.
Thank you very much.
Is that correct, gentlemen? All right. All right. Now we have a motion now that is a motion by the defendant. The court having previously entered an order that the defendant would be of counsel in the record. The defendant has filed a motion. It was filed in bank and considered in preliminary argument in bank with Judge Joplin from Columbia County, or the Third Circuit. And the court will call on that motion now in its entirety for consideration and decision. Mr. Bundy, are you ready to proceed with your motion?
I have no testimony. I don't know what the public defender intends to present in the way of testimony, and if he intends to present nothing, I suppose we can go directly to oral argument.
All right, sir. State have any evidence on the motion?
No, sir.
All right. You may proceed, Mr. Bundy.
Your Honor, I outlined in my motion several of the key factors that influenced my decision to ask for the removal of the public defender's office. And upon consideration of my motion, I just have a few additional comments and things that might go to my belief that my public defender counsel have not effectively presented my case up to the present time. We're in a difficult area here, and it's not my intention to attack my lawyers personally.
Very few things in the law are personal.
Certainly.
There are differences of opinion, but very seldom are there personal matters, so the court understands that.
And furthermore, I'm going to attempt to restrict as much as possible my comments as they deal with attorney-client communications which are privileged. And I'd like the court to understand that the court, perhaps I should put it in the form of a motion, that to the degree that I reveal attorney-client communications which are privileged, that I only waive that privilege to the extent to which I reveal or might reveal confidences between my counsel and myself. That is to say, should the public defender wish to comment by way of his own defense on matters which I have revealed that are privileged, that those revelations be limited in scope to the specific nature of what I have revealed.
Judge, could I just maybe set Mr. Bundy at ease on this? I don't intend to say anything in rebuttal, so I don't intend to amplify whatsoever anything that he says.
Go ahead.
It's my contention, Your Honor, that based perhaps upon the evidence that the public defender's office has been confronted with, based perhaps in part upon the community atmosphere surrounding the prosecution of this case, and perhaps upon other factors that I'm not aware of, my counsel have communicated to me, one, a belief that they cannot win this case, and two, a belief in the futility, as it were, in going to trial. This does not say that they have not at the same time tried to assure me that should I wish to go forward, they would do the best within their powers to defend me. But with the caveat that they have expressed to me in the past, it sort of took the heart out of the defense. That is to say, that I will receive a defense from counsel who feel that they're just not up to representing the defendant in this kind of a case. That I receive a defense from counsel while trying their best, simply don't believe that they can present it effectively or persuasively. And in the case of Mr. Minerva, that I receive a defense from counsel who believes in my guilt to some degree or another. I don't wish to say anything more about the issues I raised in my motion, except to say that I feel that some of the errors in judgment made by my counsel, perhaps caused by their attitude and by the community atmosphere, have gone from pure errors of judgment and crossed the line into the area of ineffectiveness. And I discussed with Your Honor their position on their actions with respect to change of venue, their actions with respect to the odontological bite mark evidence, and a couple of other things. I might also say that counsel and I have discussed on a number of occasions the need for a continuance in this case. That is, presently, the need for a continuance. That last Thursday, ostensibly, that was the time when such a motion was to be filed. I have been told that a motion has been prepared by my public defender counsel for a continuance, outlining in some detail the reason why they are not prepared to go to trial. I assert that attorneys who are not ready to go to trial are not effective. That attorneys who have not been able to take full advantage of a defendant's right to due process of law cannot, by definition, be effective. And yet, recognizing the continuance was necessary, and having recognized it for some time, certainly my counsel were aware of the need for a continuance during the pretrial hearings, which began on May the 14th.
What is the need for a continuance, Mr. Bundy?
What specifically?
Yes, sir.
Why do we need another continuance?
Yes, sir.
Well, Your Honor, I think from my limited knowledge of the case as it stands now, and I'll bring this up later, I think one of my complaints is that I have not been kept fully informed as to all the developments within the case. And there are a lot of things that have transpired since January or December of last year when I allowed the appointment of the public defender's office that I am not aware of. I have not received, for example, discovery delivered from the state, by the state to the public defender's office since that time. I have not received copies of the depositions taken by my public defender counsel since December, January of this year. So I don't know, and this is to me a basic problem, I don't know just where we stand in this case. But from what I do know, I can say that a principal area where we're not prepared presently to go to trial in concerns the bite market. The court knows that we presented the testimony of one forensic odontologist, that of Dr. DeVore, and yet I think the court can take note that Dr. DeVore's state of preparedness was something short of complete, that he had not prepared his exhibits, that he had not had time to finish his examination of the tissue. He has not even had time to consult other odontologists concerning his own findings in this case. These are things I know personally and have been led to understand from my attorneys.
You understand that the scope of that was solely as to whether it was competent for the purpose of introduction.
Exactly.
And not the question involved at all as it related to its use.
I understand that, Your Honor, and yet we may have been prepared to present the issue of the admissibility, but we are not prepared, at the present time, to present the issue of the credibility or the weight as it goes to the bite mark evidence.
And the court wouldn't expect you to be as far as any pretrial motions on the sole issue of admissibility.
Certainly.
There is a distinction, and I'm sure you're aware of.
Yes, Your Honor, I'm aware. That, to me, is one of the key areas that mandate a continuance at this time. Mr. Minerva knows a great deal about Dr. DeVore and some of the limitations that are now inhibiting Dr. DeVore devoting all his time to working on this case so we can be prepared for a trial which would begin today and his testimony be required a week or two. But because of these limitations, because of the amount of examinations that remain to be done, Dr. DeVore simply is not, I don't believe, from what I've been led to understand, ready to go forward. Nor are we ready to present that area of our defense.
Will you ever be until you hear the scope of the state's evidence?
I think we've seen the scope of the state's evidence. That is,
You don't think I'm going to let everything in evidence that we heard on those motions, do you?
Well, I'm assuming the worst, Your Honor.
Let me set that assumption aside. We're going to follow the rules of evidence. I ruled only, Mr. Bundy, that the evidence I thought had reached a status, as you placed in your motion, a status of credibility where the testimony in and of itself has reached scientific certainty for admissibility or a standard. The scope of a lot of things are gone into in motion proceedings before the court that, as you well know, judging from your pleadings, are not going to be the scope of what takes place that's in front of the jury. Now, there might be some out of the presence jury proffering, or there might be some out of the presence of the jury qualification. But those factors are what take place. Go ahead.
To my knowledge, we have not received the discovery which the court ordered, I think it was a week before last, specifically as it related to statements that we were seeking from residents of the Kaimega House. This may have been turned over to the public defender, and I have not been made aware of it.
Other than the depositions that you took?
Yes, Your Honor. We believe those to be potentially very critical to the manner in which the defense is presented.
All right.
I'd like to tell the court in that regard, I filed an answer to discovery stating that they were available and could be taped. They have not been transcribed, and they're available anytime you'd like to listen to them, tape them, whatever you want to do with them.
As I say, Your Honor, I'm not sure of all the things that require a continuance at the present time. This is why I urged Mr. Minerva to file his continuance with the court. The motion he had prepared and has had prepared for some time, but Mr. Minerva felt that since we were in a temporary adversary position, that he would file no motions until that potential conflict was resolved. I do think because my public defender counsel are more intimately familiar with a lot of the information that we have acquired since January, that I can't lay out for the court in great detail the things that we have not prepared fully for trial. I might say that we keep receiving new statements from the state concerning other witnesses, or in the case, an officer who was revealed to us recently a statement concerning an alleged eyewitness identification, and that has to be gone into. But apart from the motion for continuance, and I think that not only on the grounds that we're unable to prepare, we're not prepared to go forward with trial, but also because of publicity is another factor that I might raise with regard to the continuance, Your Honor. The pretrial hearings generated a great deal of publicity, specifically as they related to the bite mark evidence. And recent publicity as early as this morning concerning the alleged findings of the psychiatrist is going to receive a considerable amount of attention, I would expect. All these things would tend to taint prospective jurors in this jurisdiction. And we should allow some time to see if it is possible for the awareness of the local community to subside to some degree.
Mr. Bundy, entertain not for 1 second in your mind that this court would not change venue if legal qualifications are present before the court in order to do so. There are a lot of ramifications in the law concerning change of venue, the last of which is questioning the individual juror that is before the court. for the purpose of the court to make a determination as it relates to the possibly as low as an appearance of impropriety. And I will assure you, sir, if this court detects that, you will get a trip out of Tallahassee. I will assure you that. Your attorneys are aware of that. You might not be, and the court wants to explain that to you if it becomes necessary. This trial is not going to be tainted from as long as this court is presiding, this judge is. We're going to proceed fairly and impartially and with as much respect to you as we can give. I want you to know that. I want you to know that fully. Your attorneys are aware of the law as it relates to the change of venue and the position that the court has stated. The court stated from the bench at the close of the other proceedings, the questioning of venire. And that simply means we're asking individual jurors, for that is the community test. And we will do that, Mr. Bundy. Your motion for change of venue is under advisement by this court. It is incomplete. This court has read every document that was attached to it. And I am as cognizant of the ostensible pressures as you are. I want you to feel free in that. And I communicate solely for that reason. The court's mind is not concluded, nor is it concluded on the concept that we're going to move it. It is just simply not reached the factual determination where we can make a move.
Well, I thank the court for that advice and those insights, and yet at the same time, I hope Your Honor will appreciate the feeling that I have and the advice which I have received from counsel, which indicated to me that we were putting the court in a box the closer we got to trial date, that we were forcing upon Your Honor a great deal of public pressure to get this thing over with, and that by calling 400 prospective jurors and by calling and subpoenaing a great number of witnesses on June the 11th, the situation was such that the court would be inclined to do everything within its power to find 14 persons in Leon County who would be willing to get up there and take that oath.
I think that's probably a fair statement. We're going to do everything legally possible. If you adjust that by that degree, then we're making a statement in communication. For we're not going to proceed. And you see, involved in that term is the concept that you receive and qualify a fair and impartial jury. That's where the court is headed. That's the mandate that I'm under from the law. And being in a box, my friend, is nothing new to this court. I've been in a few before. And sometimes you make good judgment, sometimes you don't. But it's always a judgment based on one concept, that we're going to give you a fair and impartial trial. I raised my right hand to that a number of years ago and still feel very strong on the subject. So don't think that we've made any decisions yet.
The defendant and the defense's idea of what is fair and impartial might differ somewhat from what the court's idea.
It always depends on whose ox is gored. We'll understand that.
That's a phrase made popular by Judge Rudd, but I'll agree with you.
Well, he happens to be correct.
Yes.
I think somebody used it before him, though, didn't he?
Probably did.
All right.
Let me conclude, Your Honor, by, as regards the motion to replace counsel, by saying that I don't feel and I don't believe that I have been kept informed of important developments in the case. There's been a great amount of activity in the case, depositions taken, discovery received, witnesses questioned. And I am simply not aware of that information, have not been consulted concerning its accumulation. I'm not aware and have not been approached by counsel concerning trial strategy. We have not discussed at any length whether or not I will testify, what questions will be asked on voir dire, in what method, in what way will the defense witnesses be presented to orchestrate the defense. I at this time don't even know the results, for example, of the poll that was taken on my behalf. And while many of these things in and of themselves may seem to be just a defendant's desire to be informed and perhaps something capricious or demanding in my own attitude toward the performance of my counsel. I think there is in the totality of circumstances surrounding the relationship between myself and my counsel, wherein we cross that line between difference of opinion and reach the point of ineffectiveness of counsel, where because of the attitude of counsel concerning myself, concerning the evidence, and concerning the community prejudice, because of that kind of demoralized perspective, my counsel are not capable, perhaps, of presenting the defense in an aggressive and productive manner. That perhaps, and it seems to me certain, that my counsel have lost the ability to be advocates and have found themselves more in the position of being apologists for the position of my innocence. So I respectfully ask the court to consider my motion and appoint counsel to replace the public defender's office of the Second Judicial Circuit.
That, or you seek the concept of representing yourself. Your motion is in the alternative.
I know, Your Honor, and I would this time like to inform the court that it is not my intention to represent myself without co-counsel or without lead counsel, that is to say, counsel of record, that I do not see that as a viable alternative and would simply ask the court to strike that as a possible remedy. If my attorneys are not capable of going to trial, I certainly am not. Certainly not
Well,
by
you
my...
have a constitutional right to do so.
I understand that, Your Honor, and I would exercise that only to a limited degree, that is, as provided for by the Florida Constitution, that I be allowed to represent myself together with counsel.
I think the Supreme Court of the United States has spoken on the subject also.
In Minerva versus California, yes.
All right.
Thank you.
Anything further on the motion? Do you have anything further on the motion?
I do not.
Mr. McKeever?
Judge, I tell you, if that record doesn't represent effective counsel, I don't know one that does. I'll tell you right now, and here I am railing and snorting and kicking up the heifer dust again that the state wants this trial, and I feel like I've heard it and heard it and heard it. But I don't know 3 prosecutors in this state that have worked harder in the last 12 months than the 3 on this case. And it's because of how effective that counsel has been. And I'm sure the court knows what a general criminal case file looks like, and I'm sure the court is similarly impressed with how thick and how no stone has been left unturned by this counsel in this case. But you've heard all that. You've heard the state talk about how its witnesses are disappearing and forgetting details daily, and you know about the state's right to a speedy trial. And heck, the last time we were in here on continuance in bank, the court's own statement was it's going to take a national crisis, a national emergency to set this thing off again. And I hope that the record is clear that the state's going to insist that the court not withdraw from that feeling and that ruling. Now, with all that railing and snorting aside, let me give you some law. Brooks is...
That's not nearly as important as railing and snorting. I've read the law.
Brooks is cited down through years again and again, and I'm sure the court's aware of it, but it's always fun to read into the record, and I kind of like to refer to it in this situation. 172 Southern 2nd, 876. It's out of the 1st District. They start off kind of slow, and they refer to the record as being thick and the public defender as being competent, capable, and vigorous. And it's just amazing how a record that big could ever be created. It sounds just like the argument we're making here. In that case, also, they state, as we view this question, Brooks is of the opinion that an indigent may unilaterally determine that counsel appointed to represent him has been ineffective and ineffectual in the trial, and discharge of such counsel and demand other counsel be appointed to represent him. Same question. Then they really get into it. They looked at the federal court law, Judge, and they cite federal case after federal case, and they narrow down on one out of the 8th Circuit, Johnson versus United States, which is at 318 Federal 2nd, 855. And they give us this conversation between the court and that defendant, Johnson, immediately prior to trial, just like we're sitting here today. I've appointed Mr. Flynn as your attorney, and he's a good lawyer. He was in the district attorney's office for years. He's in the private practice now, and I know of no man who's more capable of advising you as to the law than Mr. Flynn. And you say you don't want Mr. Flynn to represent you. Defendant Johnson. No, sir. He's had 6 months, and he still hadn't done enough. What I say is I believe Mr. Flynn would do the best he could, but he doesn't understand the points I want to raise. The court. I see. He doesn't understand. You realize you're entitled to a lawyer. The court's appointed a lawyer for you, and he's a good lawyer. If you don't want this lawyer to represent you, you have a perfect right to try your own case. I'm not going to appoint another lawyer for you. I'm not going to do that. I've done all that the law requires. I've appointed a good lawyer, and he's advised you, and if you insist on a trial, I suppose Mr. Flynn should sit here and see that the defendant is properly given a fair trial. If you don't want him to do that, then I think he must be excused. Is that what you want? Defendant Johnson, it sounds almost like Bundy's argument. Well, I would like to see that my constitutional rights, and then the court cuts him off. I have done all I can do for you. I am not going to appoint another lawyer. If you want Mr. Flynn to withdraw, all right, but I'm not going to appoint another lawyer. First District found that to be a competent waiver, and the reasoning behind their ruling is really fascinating. The constitutional right to be represented by counsel does not, of course, guarantee an attorney with whose advice the defendant can agree. On the other hand, the public welfare demands that such a procedure be carried forth in an orderly manner, talking about appointing a lawyer to represent it. Otherwise, the judicial system becomes a mockery. Society as a whole reverts to the law of the jungle. To permit a jailhouse lawyer to seize upon every imaginable incident as being a deprivation of a constitutional right and thereby disrupt the judicial processes to such an extent that a final disposition of his cause is postponed beyond the availability of witnesses, and if they're not talking the same language, I don't know who is to say in the name of due process that justice is not available to the citizens of the state against an individual. To permit a defendant, be he indigent or otherwise, to conduct on the one hand the trial of his cause as he deems advisable, but on the other hand to scream that he's been deprived of his constitutional guarantee because he's not furnished at the expense of the general public an attorney who concurs with him is completely disregard the purposes for which counsel's furnished. And that's the point here, Judge. Bundy doesn't have any idea the reason why we appoint counsel to represent people. It's not to go on ad infinitum until he's happy with the case. Counsel's not provided, and I'm reading again from the case, not provided for the purpose of serving as a mouthpiece for the defendant, nor is such counsel required to conduct himself as an errand boy to carry out the defendant's legal theories, and once failing so to do, to be summarily discharged by the defendant, another and another and another appointed for such purpose. We are fearful, this is the First District Court of Appeal, we are fearful that the basic function of a lawyer appointed to represent a defendant has to a great extent escaped not only indigent defendants, but in many instances the appellate courts. And that took a shot at themselves on that one, sound like. Like I say, Brooks has been cited again and again and again. Most recently, we have the Wiltz case, W-I-L-T-Z, which is out of your own bailiwick down there, the Third District Court of Appeal in '77. Came out of Her Honorable Judge Morphonius' court.
I got the slip sheet.
Judge Morphonius, you have read this case. Rather than drag it through again, Judge, the bottom line in that one was that, in our opinion, there's no reason for the court to appoint a substitute counsel for the public defender merely because counsel gave defendant his appraisal of the case, assuming that counsel did so in this case. Indigent defendants have no right to select their own lawyer. We've been over that again and again in the Farmer argument. Basic law that we're suggesting the court follow. In that one, Judge Morphonius got kind of rough with him and gave him an 11-day continuance and ordered him to trial and didn't give him any advisory counsel. Now, we think the law would support that kind of a ruling today. We think that the law would find it a proper trial if he sat there all by himself and went through this trial. But I'm not suggesting that, Judge. I think he's got one of the most competent lawyers that you could find, and I'm not saying one, I'm saying three. We have never been in this courtroom with less than 3 public defenders standing by either advisory or working the case or helping Mr. Bundy. Ferretta. The footnote from Ferretta versus California, and that's F-A-R-E-T-T-A, 95 Supreme Court, 25-25-75. Of course, a state may, even over objection by the accused, appoint a standby counsel to aid the accused if and when the accused requests help, and to be available to represent the accused in the event the termination of the defendant's self-representation is necessary. That's what I'm suggesting the court do. I don't think there's a lawyer in this state, even if we followed Bundy's desires and went out and looked for one, who's better ready for this trial than Minerva and his two associates. And I'm suggesting today that the court appoint Minerva at least advisory counsel. I think probably the record alone supports him being chief counsel. But if Bundy wants just an advisory counsel situation, then I think the law would support that. But I do not think this court can, and I hope it's not going to, make this court a mockery, make this system a law of the jungle situation where we go lawyer after lawyer, continuance after continuance. By golly, I think the court ought to stick to its statement that we need something like a national crisis to put this thing off again. And we've got competent counsel, and the state is insisting that we go to trial.
All right. Mr. Bundy? Any response?
Mr. Minerva. Well, we have a national crisis, Your Honor, but I don't know if it relates to this case. Mr. Minerva, pardon me, Mr. McKeever has stomped and kicked up the heifer dust in his own inimitable way, and so I suppose that we expect the prosecution to say those things because the prosecution wanted to go to trial 2-3 months after the indictment was filed. And I suppose that there are probably better endorsements of the effectiveness of my counsel than as to whether or not the prosecution believes that I am getting a proper defense. But in spite of the vigor of Mr. McKeever's presentation of the law, I might say that perhaps Mr. McKeever does not understand the needs of the defense in this case, and perhaps because of his adversary relationship is not in a position to make decisions for me, is not in a position really to understand whether or not my counsel can communicate and whether or not they are effective. Your Honor, this is not on my part a capricious or whimsical disagreement with my counsel. As I said, I can look back on my relationship with counsel and they can look back on their relationship with me, and we can find all sorts of disagreements of matters that go to whether or not we should have done this or that. And certainly these do not raise themselves, these disagreements do not raise themselves to the level of ineffectiveness on the part of my counsel, if in fact I disagree. Your Honor, it is not simply my own point of view that I'm not receiving effectiveness of counsel. It's my position that my counsel, 1, believe that I am guilty, 2, that they have told me they see no way of presenting an effective defense, and in no uncertain terms they have told me that, and 3, that they see no way of avoiding a conviction. Your Honor, if that does not raise itself to the level of ineffectiveness of counsel, I don't know what does. We're not talking about whether or not A witness or B witness goes on the stand. We're not talking about whether this piece of evidence is critical or that piece of evidence is critical. We're talking about whether or not my counsel can effectively defend me, whether or not they have belief in themselves, whether or not they can effectively and positively present a defense, not that is in line with my peculiar ideas about what a defense should be. But here we have the ultimate goal which is in conflict. Your Honor, I am here today because I wish to be acquitted, because I assert my innocence. If my counsel tell me that they can not do that for me, if my counsel tell me that there's no way that they can see, or very little chance that they can see, of achieving that goal for me, then I say that we have some fundamental problems, some fundamental conflicts, and those conflicts amount on the part of my counsel to ineffectiveness in a constitutional sense.
Minerva, you wish to say anything to the court? You filed a separate motion to withdraw it. As I glean, it's primarily based upon the motion that was filed by Mr. Bundy. Is that correct?
Yes, it is correct, Your Honor. And if the motion is going to be heard at this time, then I would like to be heard. Otherwise, I'll defer until the court rules on Mr. Bundy's motion. So whatever
I think we can take them both together. I believe I can separate the applicable facts. If you want to proceed on your motion to withdraw, you may do so.
All right, sir. Your Honor, I do not want to take issue with
We understand
anyone.
concerning factual issues. Appreciate that.
Well, I'm not going to, Your Honor. I think it's nice that the state has said what they've said about us, but I hope that the court takes that in terms of argument of counsel and not factual matter as to our effectiveness.
You notice I made most of my notes during his recitation of the law and not the fire and brimstone that he referred to.
Your Honor, the motion to withdraw very simply says that the defendant has asked that we be withdrawn, and that as a result of the motion, there are some ethical conflicts, not inconsiderable, that arise from the motion. And particularly, Your Honor, Canon 5 of the Code of Professional Responsibility, which I know the court knows, very simply says a lawyer should exercise independent professional judgment on behalf of the client, and that in the ethical considerations that are appended to that, it says that the professional judgment of the lawyer should be exercised within the bounds of the law solely for the benefit of his clients and free of compromising influences and loyalties, neither his personal interests nor the interests of other clients nor the desires of third persons should be permitted to dilute his loyalty to his client. Now, part of that I'm concerned about, Your Honor, is the personal interests of counsel diluting the loyalty to the client, and also the canon that deals with the obligation of counsel to defend his client zealously. Your Honor, regardless of the truthfulness or the validity of any of the statements made about how we have counseled Mr. Bundy, or how we failed to counsel Mr. Bundy, or how we have prepared or how we have failed to prepare, or what we have presented or failed to present, the question now comes to whether the defendant can receive from us the constitutional right to counsel, in the sense that counsel should be free from the fetters of any possible division of loyalties. What has been presented by the defendant is unfortunately taken seriously by me, and probably I shouldn't do that. But I cannot stand here and tell the court that I can disregard what's been said, even though it may be true, and even though Mr. Bundy may be correct. What I am worried about is that because of the proceedings, my loyalties may be divided between my own personal interests, my own personal feelings about his defense, and the obligation that I have as an attorney not to have any influences other than his best interest at heart. And in the situation that we're in now, Your Honor, I could never be sure that my future advocacy in this case would not be tempered to some degree by what's been said in court. Now, I might act or fail to act in a manner that's detrimental to Mr. Bundy, out of a conscious or subconscious feeling of animosity towards him. I may hold back from pursuing as vigorous a course of advocacy as is required because of what's happened. Because I might be more concerned for my own interests than for his. Now, I'm not blaming him for filing the motion. And probably if I was in his position, I would have done the same thing, and maybe been a lot harsher. I'm not saying that he is wrong, and I'm not saying that I have any statement to make in defense of what he said. But I'm saying that because I was subjected to criticism in public, that I will never again be able to act in his behalf without possibly hearing some distant remnant of what was said and having some taint of self-interest or some voice holding me back from the course of action that I should pursue on his behalf. And when the canon says that you shall defend the client zealously, it means completely zealously and without regard for your own feelings. Now, this case is particularly difficult, and it will require taking some risks, possibly of censure from the court, rebukes, taking positions that are going to be unpopular. And for the constitutional protection of Mr. Bundy, I think that he should have a lawyer who does not even have any hint or suggestion of another influence that might hold that lawyer back in his efforts to defend the client in accordance with the canons and in accordance with the Constitution. So therefore, Your Honor, for the protection of Mr. Bundy, and so that he will have the Sixth Amendment right to counsel, full counsel, counsel who is untainted by any possible suggestion of personal interest, I think, and I urge the court to grant the motion to withdraw.
How long do you think it would take substitute counsel to be prepared to go to trial in this case, Mr.
Your Honor, I think it would take quite a while. We have been in the case as counsel since December. And I will tell the court that we do not consider ourselves, at this point, fully ready to go to trial. But I would hope that the court would consider the question of the constitutional right to counsel separate from any question of continuance, because I think that that is of paramount interest. And I am afraid, Judge, that what's taken place will possibly prevent us from really being judged effective in the future. And I think it's just fundamental as to counsel.
All right.
Well, what you've got, Judge, is one of the toughest decisions we ever face as lawyers, is two sides with fundamental rights. And I'm reading from Dickey versus Florida, and I can't for the life of me understand why I don't have just as big a right, or the state doesn't have just as big a right to get this thing to trial. Dickey versus Florida in 1970, 90 Supreme Court, 1564. Speedy trial clause protects societal interest as well as those of the accused. The public is concerned with the effective prosecution of criminal cases, both to restrain those guilty and to deter those contemplating. Just as delay may impair the ability of the accused to defend himself, so it may reduce the capacity of the government to prove its case. Judge, the man runs the risk in January, when he's appointed a lawyer, that he's got to work with that lawyer every day that they can. 3 of them working with him for 6 months. And by Bundy's own statements, Bundy ain't happy, and therefore we got to put it off. There's not another lawyer in this state that isn't going to stand up 6 months from now and say just what Minerva said. Bundy's going to do the same thing to him, and then he's going to hear the little voices out there about how, boy, I don't know if I was affected in that trial or not. The state's got a right to trial. This crime occurred 18 months, getting on near 18 months ago, and there hadn't been a single delay since indictment except for Bundy's making a delay in this case. And I can't emphasize more strongly with Brooks and Dickey and Wiltz and Ferretta that the state and this public community have a right to this trial, and they couldn't have a more competent lawyer sitting over there than Minerva. Now, I'm not saying, don't want you to misunderstand me, that he needs to be chief counsel. I'm not sure, but what they might have problems to where he can't call the shots himself anymore. If Bundy wants to be chief counsel, he needs to understand the state of the law. He's liable to be sitting there all by himself. Just liable to, because the law will support that kind of a ruling. And he's had plenty of time to get ready. He had 6 months to get ready by himself before he jumped out and got Minerva on the case. Then 3 lawyers to help him get ready. The record reflects time for trial. And we're suggesting to the court that if it's not going to put the man to trial by himself, there's no more competent lawyer, 3 lawyers in the state, than Mr. Minerva's office, and we couldn't have a better situation to go ahead and get this thing to trial.
All right, gentlemen. There is raised before the court a very fundamental question of due process